A major luxury retail brand spent almost £9,000 in legal fees to defend a claim for a bag of just over £2,000. And this is that story. So this is a true and relatively simple story, with the names left out for obvious reasons, where a lady went to a luxury retail brand to buy a bag for her husband. She wanted to buy something special, top end and rather expensive. She went along to this store and had a look around and chose something with the help of the sales assistant. She wasn't quite sure whether it was going to be suitable for her husband's needs, so she had a conversation, much like many of us would do, with a shop assistant when buying a gift for somebody else. She asked the shop assistant whether she could return this bag if it wasn't suitable for her husband's needs. Of course, as most shops do, the sales assistant said, yes, of course, you can bring it back and exchange it, or even for a refund if it's not quite suitable. And with little to no examination of the bag, she agreed to purchase it, and off she went. She put the bag in a cupboard at home and waited till the time was right to gift it to her husband. Sure enough, when he opened it, however grateful he may have been, it just wasn't quite suitable for his needs. It was a little bit small and he needed something a little bit bigger. So they decided as a family they were going to return to the store when it was all convenient and shop for something else, and they were quite excited by this. The day came when they went to the store as a family, they had a look around and chose something that would be a little bit more suitable. They went along to the shop assistant, not the same one that it was the first time, and said, we bought this before, we'd agreed to exchange it, this one is more suitable. In fact, it was very slightly cheaper, so there was a bit of a refund to be had as well. Shop assistant said, no problem at all, I can process the refund and exchange for you, but I'll just need my manager's authorization first. The manager came over and thoroughly examined this bag and then proclaimed that it looked like it had been used and there's marks of wear and tear. All of which, of course, the lady and her family denied, because the bag hadn't been used. It had only been examined by her husband to find out that it wasn't quite suitable. Conversations were had about consumer rights and how consumers should be treated and so on, as you might expect. The position here, of course, is one of simple contract law, and consumer rights provide additional rights to consumers. Fact of the matter was, as far as the lady was concerned, was that there was a contractual agreement whereby she could bring the bag back and exchange it for something else if it wasn't suitable. And she was exercising that option as she'd agreed. Nonetheless, the manager stuck to his guns and refused to provide an exchange or a refund, and the family went away disappointed. Sometime later, a claim was filed in court for a refund of the cost of the bag. The company filed a defence to the claim and, rather bizarrely, as part of the defence, invited the court to exercise its case management powers and strike out the claim entirely for disclosing no reasonable grounds for bringing the claim in the first place. Of course, this was not true, because the particulars of claim set out fairly succinctly what had happened, what was agreed, and claimed a refund for the amount paid under the contract for the purchase of the bag. A little while later, the claim was allocated to the small claims track. That is typically for claims that are worth not more than £10,000 and for which legal fees are not normally recoverable, although the court does retain overall discretion as to costs, but usually in limited circumstances where the litigation has been conducted badly. I, for example, have achieved costs in such claims because the defendant on the other side has acted improperly during the litigation process, but ordinarily those costs are not awarded. So I was instructed to represent the claimant in court, and we heard evidence from members of the family and from the shop manager who'd declined to exchange or refund the bag on the day. Although the initial salesperson that made the agreement neither filed a statement nor appeared in court. So the judge had to make a finding of fact about various things, including that initial conversation. Cutting a long story short, the judge found as a question of fact that the conversation between the lady and the salesperson that occurred in the store on that first day purchasing the bag formed a term of the contract, and she had the option under the contract to return the bag for an exchange for something else. The judge also commented that there was no reason to disbelieve the family in what they said happened, and concluded that the contract allowed them to take the bag back. And in its judgment, the court ordered a full refund of the bag, but not before the luxury retail brand had spent almost £9,000 trying to defend this claim. All the while, it should have been reasonably clear that these fees were not really likely to be recoverable, because this in all likelihood was going to end up on the small claims track. It was conducted properly, and there was no real reason why the defendant company was going to be awarded any of its costs, even if it successfully defended the claim. So the moral of the story is, if you're buying something very expensive, then even if it isn't written down, a judge can make a finding of fact that the conversation between you was a credible conversation and it formed part of the contract. Although, of course, that's not best advice. Best advice would be to get everything written down and ideally signed by both yourself and the salesperson. Even though that makes for a little bit of an awkward conversation between yourself and the salesperson, it is better that it's written down at the very least. You put a date on it, even you sign it if the salesperson refuses to sign it. This is likely to form even stronger evidence than in this case that I was instructed in here. But in this case, it was a successful outcome for my client at a cost of almost £9,000 to the defendant company. I'd be interested to read your comments down below. Give this video a thumbs up if you'd like more stories, and remember, stay humble and subscribe.